Good morning, everyone. I'm Judge Jackie Powell, and this is Magistrate Court. This is your first appearance. In the courtroom today, I have attorneys from the State Attorney's Office, Mr. Eric Linder, attorney from the Public Defender's Office, Mr. Brian Reedy, and there's an attorney over at the main jail as well. In the courtroom also, I have pretrial supervision services representative, confinement status, and the clerk's office. Today's not your trial. Today, when I call you up, I'm going to tell you what charges you're facing, and then we're going to talk about release conditions. And because today is not your trial, my advice to you would be not to speak about your case. If you are represented by the attorneys from the Public Defender's Office, you want to speak with your attorney before you attempt to speak on the record, or they'll speak on your behalf. If you have a private attorney and that attorney's in the courtroom this morning, then that person also will be able to speak on your behalf, and you'll be able to see them on the screen. So we have a big docket this morning, and I'm just going to start from the top, and we'll see how we can get to those in the courtroom who have already signed in. All right, so we will begin this morning with Ali McInnes.
He's approaching, Judge, here at Maine.
Mr. McInnes, good morning.
Good morning.
Sir, you're before the court today so that I can tell you that there's an out-of-state felony hold. You're being held no bond, and next Tuesday or Thursday, you should be going to extradition court to deal with this. Good luck, sir. Kendrick Hardy,
He's in North Broward, Your Honor.
thank you.
Hey, how you doing, Your Honor?
Good morning, Mr. Hardy.
Good morning, ma'am.
You are here for me to let you know that there's an out-of-state felony no bond hold for you, and that you will be going to extradition court either next Tuesday or Thursday. Good luck, sir.
All right, thank you.
These 5 people have signed in? Okay.
Hurry now. Come on.
All right, we can go to page 6. We've got Iskiela Richards.
Ms. Richard, North Broward, Judge.
Iskiela Richards.
Yes, it's different.
Did an attorney sign in for Richards?
Her brother is here, Judge.
Okay. All right, good morning, Ms. Richards.
morning,
Ma'am,
Judge.
you're before the court today for 1 count of discharge firearm in public and 2 neglecting child without great bodily harm. And the court does find probable cause. What does the parties wish to say in regards to bond?
Judge, I'm going to be asking the court to consider releasing Ms. Richards on her own recognizance. She is, I don't know if the state has an objection.
Yes, I do.
She's been a resident of South Florida for 23 years. She's been living in the same location in Davie since August, but she's been a resident of Davie for 12 years. She is the mother of, did you say 6 children?
I did.
And she has been a manager at McDonald's. She is currently employed as an assistant manager at McDonald's. She's been an employee of McDonald's for the last 12 years. From what I understand, her contacts with the criminal justice system is extremely minimal. I think there are some mitigating circumstances in this probable cause affidavit, namely that her ex-boyfriend grabbed her by the throat, punched her in the face with a closed fist, and she was acting to defend herself. She was then pushed to the floor and dragged while being punched in the face by the ex-boyfriend. Then he started to run away, and from what it says in this report, and this is the exact language, she went back to her vehicle where she had her 5-month-old daughter in a car seat and retrieved the purple .380 caliber semi-automatic pistol, put it in her jacket pocket, and followed after Funchess, the ex-boyfriend who had just beaten her. Which means that she was heading away from the vehicle where the child was when she fired the gun into the air. So I think that that's a mitigating circumstance as far as the actual endangerment of the child. I'm not condoning at all what she did, but I think that this might be the type of case that can find a favorable resolution for Ms. Richards, especially based on the totality of the circumstances. She has extremely strong family support, as the court can see. Her brother is here in court today, and I would ask the court to consider releasing Ms. Richards on her own recognizance, or in the alternative, setting a bond in the amount of $1,000, because that's what the family has indicated they could afford.
I will be requesting a $5,000 bond on count 2. Order no victim contact, Your Honor. I disagree with defense's argument that about the mitigating circumstances. This was not an act of defense based on her own admission, and I'm not. If in fact the other party attacked her, I'm not justifying that. If that happened, that's absolutely 100% wrong, and that should be investigated. However, based on her own admission, he was running away when she decided to arm herself and open fire. And the fact that she would open fire anywhere near her 5-month-old child put that child's safety at risk, and is a cause for concern. I'd also be asking for a release condition that she not be in possession of any firearms, weapons, or ammunition. I would note her criminal history: 2012, resisting without violence, battery and theft; 09, disorderly conduct.
And again, Judge, this report is unclear as to how far from the vehicle Miss Richards was when the gun was discharged into the air. So I think without more detail, which will come out, I'm sure, as the case is further investigated, it would appear at this point in time that she was heading away from the vehicle. If he was running, then I think it's a fair assumption to say that she would have had to have been running too, so she could have been 30, 40, 50, 60, 70 feet away from this car when the gun was discharged.
All right, sir, is there something you wanted to say?
I would just like to say neglect is something my sister will not do to her kids, man. My sister has 6 kids. She's also pregnant right now. I'm her brother. This is something my sister is not used to, ma'am. I'm speaking on behalf of my sister because I'm right now is in helping with her 6-month-old daughter. It's not just hard for me, it's also hard for my family because financially we can't take care of everybody at home, but my sister right now, she takes care of kids by herself, ma'am, and for them to saying things like what she done, I'm not justifying what she did was right, but I need my sister home. We need help. I can't do it on my own. And my other sister, I have 11 kids. So right now, while I'm at work, my other sister is taking care of her baby, and when she go to work, we just need my sister home, man.
All right, thank you. And I understand what everyone has said. I have to make a decision based on the information that's been presented to me. And so this morning, I do find probable cause, and I will, as I will not count to, 1 does not require a bond to be imposed. So as to count 2, I am going to impose a bond of $2,000. And Ms. Richards shall have no firearms, no contact with Travis Funches until further order of the court. Good luck.
Okay.
Thank you.
Thank you, Judge.
Nicholas Goldman on page 24.
Good morning, Judge.
Good morning, Mr. Silva.
Ryan Silber here on Mr. Goldman's behalf. With me in court is Mr. Goldman's father, John Goldman. Judge, we have a stipulated bond resolution this morning. The state will clue you into the details, but basically it's a $150,000 bond. He'll be placed on house arrest with a GPS monitor. He will not be allowed to use the internet or electronic devices, including cell phones, computers, etc. No contact with alleged victims in this case or minors, and we have no problem with that at this juncture. State, is there anything else you want to add?
I just want to go through them specifically.
Sure, no problem.
And Your Honor, it is true,
Hold on. I'm North Broward, Conti, Paul Ryan. I'm gonna ask you to turn your mics off. We're getting a lot of feedback.
thank you, Judge.
All right.
Your Honor, yes, if acceptable to the court, we've agreed on a $150,000 total bond, which did a little math, but that comes out to $7,500 per count.
Okay,
If we were better at math, we would have gone to medical school.
that's right. Okay,
And Your Honor, the specific conditions we've agreed to: no computers or electronic devices, including cell phone with a computer or smartphone. That Mr. Goldman not be in possession of a camera or any other kind of video recording equipment. No internet access. It'd be pretrial with GPS level 1, however, and while I already spoke of pretrial, this is automatically conditions of level 1, we want to put on the record, Mr. Goldman would be permitted to see his doctor for any medical necessities, and also to meet with counsel regarding this matter. No contact with minors, no activities involving minors, including coaching, may not visit any school campus or any other place where children congregate, and we are in agreement that he can continue to reside at his residence while this case is pending, Your Honor.
okay. Thank you.
Just one thing, Judge, for the record, Mr. Goldman invokes his right to remain silent.
All right, so this morning I do find probable cause for, there are 20 counts, for all 20 counts. And per agreement, the bonds will be $7,500 per count with all the conditions that were delineated on the record this morning.
Excellent. Thank you, Judge.
Thank you.
Mr. Goldman, do not discuss your case with anybody, okay? All right.
I have Austin Bailey on page 19.
Good morning, Your Honor.
Good morning.
Pleasure to finally be before you.
Thank you. Mr. Bailey's before the court for one count of violation of probation. And I don't know when, because usually they give me a date when he's going to his felony
It's in
division.
Monroe County.
Judge, it's
It's out of, not Broward.
Correct.
Okay, so,
Judge, I can tell you this.
Yes.
He is on probation for a felony battery out of Monroe County. I was the attorney of record on that case. We resolved it almost 2 years ago. There was a provision in his orders of probation regarding alcohol, but my recollection and Austin's recollection is that it was no consumption of alcohol. I saw the probable cause affidavit in this case, and the allegation is not consumption, but rather possession. I know the case is not out of this jurisdiction. I realize that. For the record, I challenge the finding of probable cause on that matter. And to the extent that the court can, if you don't find probable cause, give the state and/or the Department of Corrections an opportunity to perfect the probable cause affidavit on that particular issue. Was it possession or consumption?
Your Honor, I would just note, this actually was not prepared, this PC was not written by a BSO deputy or any officer. It was done by his probation officer, who I think the court can rely upon, since that was his officer that is supervising him, that his officer would be familiar with the conditions of probation. I am familiar, Deborah Miller is and you can see, she's with the Florida Department of Corrections.
Just add one more thing that Mr. Linder wouldn't be aware of. Mr. Bailey's probation officer is actually a lady, a nice lady by the name of Heather Bischoff. This was a supervisor who for whatever reason, randomly checked in on Austin's case. And again, as an officer of the court, in speaking to Ms. Bischoff, she also advised me that since she was going to be submitting a warrant anyway, and I don't know whether or not that's been done, she was gonna add some other technical violations such as monetary obligations. But yet probation runs until, I believe, the end of June of this year. I guess, Judge, what I'm saying is, I'm asking the department to clarify the probable cause affidavit as to whether it's possession or consumption of alcohol. And in an ideal world, I'd like Austin to stay here and see if the judge in Monroe County signs a warrant.
And Your Honor, just noting, if probation is confirmed to Mr. Amoroso that they're submitting a warrant, then it is probation's belief that the condition is no possession of alcohol.
Right. All right,
I know.
and it's Monroe, so I can't pick up the phone and call the judge and say, what do you want me to do? So I find probable cause, and I'm sure that you are going to work very hard on Mr. Bailey's behalf to get this resolved. Good luck, sir.
Thank you, Your Honor.
All right. All right. All right, I have some private persons who have signed in, but you're far down on the docket, and the attorneys need to get time to speak with those persons. So I'm gonna keep moving, and you're gonna have to wait a little bit, because unless they have a private attorney, it's a public defender's office, and if they're on page 31, I don't know that they've already spoken to those persons. All right, just so you know. All right. So then we'll go to Michelle Marino.
I believe North Broward, Judge.
Approaching.
Yes, Judge. Ms. Marino would like to resolve this matter as smoothly as possible.
Okay, that's no problem.
Ms. Marino, good morning.
Good morning.
Ma'am, you're before the court for one count of possession of cannabis, 20 grams or less, and then there are 2 municipal ordinance violations that are attached. And I do find probable cause, and your attorney tells me you wish to resolve your case today. Is that correct?
Yes.
All right, State, do you have an offer?
On the cannabis withhold courthouse, Judge.
All right, so Ms. Marino, if you wish to resolve your case, the offer is a withhold adjudication and court costs. Do you want to do that, ma'am?
How much is the court cost?
It is 200, no. 300 and what? It's $308, ma'am, and I'll give you time to pay your court costs.
Yes, I'd like to resolve this.
All right, please raise your right hand.
Your Honor, she also has 2 municipal ordinance violations.
Yes, I will.
Okay.
Do you swear or affirm to tell the truth, ma'am?
Yes.
All right, please put your hand down. Do you understand the proceedings that you're in today?
Yes.
And is anyone forcing you to resolve your case today?
No.
Do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for a mental or emotional illness?
No.
Do you understand that you have the right to go to trial, that by taking a plea, you're giving up that right?
Yes.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes.
Ma'am, what plea do you wish to enter today? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. As to all counts, your sentence is a withhold adjudication and court costs. And ma'am, I'll give you 6 months to pay your court costs. Good luck.
Thank you.
Peggy Morris.
She posted bond, Judge.
Bonded, Judge.
Thank you. Gloria Pentelis. Gloria Jean Pentelis. She was on medical loan yesterday.
I believe she's still on loan, Judge.
All right, thank you. Natalie Wilson? Williams, Natalie Williams. I'm sorry?
Hold on, Your Honor.
Good morning, Ms. Williams.
Good morning, Your Honor.
Is Ms. Williams represented by the Public Defender's Office?
I know Ms. Williams has another case with some no bond holds on it. I don't know if we have opened a file.
Your Honor, I can tell you on that case, private counsel was present last week for the first appearance. However, as of yet, no one has filed a notice of appearance per Odyssey.
Okay,
I did request, just in case for the public defender's office, because my mom did not pay the full amount for the attorney.
okay.
So if I am able to have representation right now with the public defender's office, I will accept it if that is possible.
Well, I'm going to recall your case because I guess they'll need to speak with you.
You know what, that's okay.
And this is an ad charge, so
And it's completely separate from that case.
it's separate from the other case.
I'll just take care of it now, ma'am.
All right, ma'am, you're before the court today for count 4. It's a home invasion with a firearm or other deadly weapon. And I do find probable cause. What does the state wish to say as to bond?
Your Honor, based on the allegations contained in the affidavit, I'd be requesting the court to make a finding of proof evident or presumption great for first appearance purposes only, that Ms. Williams be held no bond on this count, and that the court order no victim contact with Arnaldo Tomas.
All right, I do find probable cause, and I also find proof evident presumption great. Ma'am, you'll be held no bond on this case. It's a preliminary finding. No contact with Arnaldo Tomas. Good luck, ma'am.
And so the record's clear, Your Honor, ordinarily, we would object to the court making a finding of proof evident presumption great at the stage of the proceedings, but in light of the fact that Ms. Williams is currently being held no bond on the other 3 counts, we will defer that argument until she can appear in front of her division judge.
So noted.
There's no possibility of pretrial release?
No, ma'am.
Not at this point, ma'am.
time.
Okay, thank you, ma'am.
Maybe Judge Garcia Wood might do that for you, but not this morning.
Thank you.
All right, Samantha Schneider.
Hold on, Your Honor.
Good morning, Your Honor.
Good morning, Ms. Schneider. Ma'am, you're before the court for an ad charge of grand theft. And the court does find probable cause. Parties wish to be heard as to bond.
Your Honor, I'd ask the court to leave the bond in place. Ms. Schneider has some no bond holds on counts 5 and 6. So she needs to go in front of her division judge.
Okay, the bond is $1,000. Thank you.
Good luck, Ms. Schneider.
Thank you.
All right, Ronnie Kokanowitz.
She's here present, Judge.
Good morning, ma'am. You're before the court today for one count of misdemeanor KPS. Counts 2 and 3 are VOP pretrial felony warrants, with our counts 4 through 8 are felony KPS. Counts and not for magistrate. So count 1, there is a bond of $500, and then the other counts are not for magistrate. My notes indicate that you should be before Division FC tomorrow at 8:30, and then on the misdemeanor cases, you should be in court on February 18th. Good luck, ma'am. Felicia Strong.
Ms. Strong, come on up, please. She's approaching, Judge.
Ms. Strong, you're before the court today for one count of unlawful possession of a personal ID of another, 2, possession of THC, and 3 is a violation of felony probation. I do find probable cause. You have a bond on count 2 of $1,000. Count 3 is a no bond hold. You should be before your division judge tomorrow at 8:30. Good luck, ma'am.
Judge, what's the name of her judge that she's going in front of tomorrow?
It's Division FH. Do we know the? Judge Bailey, Tim Bailey. Is this next? Oh.
Here's these 3. And then these go under here.
Okay, on page 10, we have Wayne Golden. We're going out of order, I'm going by the sign-in sheet. Good morning.
He's approaching, Judge, in his corner.
Just go by the order that I get the sheets, so. Okay. On page 27, I have Jamel Demons.
Correct, Judge.
Sí, abogado. Vas a pegar uno que es de ayuda de Estado.
That's not Mr. Demons.
Bradley, on behalf of the state, may I approve with the affidavit we're relying on?
Sure.
Judge, who did you call?
Demons.
Oh, sir, you can take your seat. Mr. Demus, come on up. Your private attorney's right there.
Judge, good morning.
Good morning.
Right there.
Judge, Mitch Palayan on behalf of Mr. Demons. I'll be filing a notice of appearance along with Bradford Cohn on this case, sometime this week.
Okay.
And as the court knows, it's a murder one. So we're gonna ask that his rights be invoked and that no police agent and or detective or police officer make contact with Mr. Demons at this time. Okay, don't speak to anyone, you understand that? Mr. Demons, you hear me?
Yes, sir.
Okay.
All right.
Good morning, Your Honor.
Good morning.
Christine Bradley on behalf of the state. I've given to your honor, but specifically not to defense counsel, to preserve any rights of some of the co-defendants charged and uncharged at this point, for your honor to review to find and finding of proof evident presumption great, as well as probable cause. That will be provided to defense counsel after this afternoon's court hearings where the co-defendant is up for magistrates.
That's my understanding, Judge.
Jamel, remember, you don't speak to anyone but me or Mr. Cohn. Remember that, okay? Jamel, that includes speaking on the telephone and/or any other alleged co-defendants, okay? Christine, Judge Weeks. Okay. Yeah, but they.
Okay. All right. So, Mr. Demons, you're facing 2 counts of premeditated murder, and the court does find probable cause. I further make a preliminary finding of proof evident presumption great. You will be held no bond. And of course, that's without prejudice to have a motion based on State v. Author.
The state would also ask for no contact with Cortland Henry, direct or indirect.
And
Judge, you did say without prejudice.
Yes.
Because that's something we'll address.
I did say without
to his
prejudice.
judge. Thank you. All right, Jamel, we'll be there to see you, okay?
All right, thank you. I just wanted to get that on there, that I wrote it on there
Thank you,
without
Judge.
prejudice. Thank you,
We'll
Mr.
see you.
Pillay.
Bye.
And, Ms. Bradley, is the other defendant on?
He is set for this afternoon, Your Honor. That was the one Mr. Bouchel came in and I agreed to give them 24 hours.
Okay.
To have a discussion about their side of the case. You can keep that, Your Honor. That's about the same affidavit that we're using for the other co-defendant. I have another copy as well if you want.
Okay,
Or if you want me to hold on to it, you let me know.
maybe you should hold on to it, because I can't give it to the clerk, so. Thank you.
Thank you, Your Honor.
All right. And then I had, on page 7, Jesse Fuentes Ruiz. Mr. Castaneda here.
Good morning, Your Honor. How are you?
Good morning,
Good morning,
I'm well,
Judge.
sir.
Representing Jesse Fuentes Ruiz. She came to our office yesterday, Your Honor. There was an error on the docket sheet. It says it's aggravated, and that's incorrect.
All right.
7,
It's
Madam
page
Clerk.
7, Jesse Fuentes Ruiz. Jesse, it says Jesse Zabeth Fuentes Ruiz. Page 7.
see her.
Check to see where she is.
Yeah, do you want to?
Yeah, she is in North Broward.
There she is.
Okay.
All right, ma'am, based on the information I have, I guess we'll address that, Counselor.
Yes.
I have 2 counts of aggravated child abuse,
That's incorrect.
okay?
Your Honor, it's 2 counts of child abuse, not aggravated child.
Okay. All right, then the court does find probable cause.
Yes, Your Honor.
What does the parties wish to say about the bond?
Your Honor, Ms. Fuentes Ruiz is married. Her husband is here present in court. My understanding is that she has no prior criminal record, and the state can let the court know if she does or not, but my understanding is she does not. There is a pending verified petition of dependency. The dependency case has been going on for several months now. There has been a plan for reunification. There has been supervised visitations with 2 minor children. Maybe not the alleged victims in this case. I'm not sure. I'm not the one handling that case specifically, but she has 4 children in total. So the children have been out of the home since October. She works full-time. She's a U.S. citizen. She immediately was notified that there was an outstanding warrant. We turned herself in immediately to the police station, and she was brought in and booked in and brought here today. We're asking for a statutory minimum bond on a 3rd degree for each case. She's not a harm to the community, and she will ensure our presence in court.
Your Honor, I'm going to be requesting a $15,000 bond on each count, pretrial release with a GPS monitor, and no victim contact until further order from the assigned judge in this division. Your Honor, the reason I'm making this request, I am greatly concerned for the safety of these children. I would note, and Your Honor, it's mentioned in this probable cause affidavit, that this is the 5th time that Ms. Fuentes Ruiz has been investigated by Child Protective Services for abusing these children. Previous investigations or abuse of her children. Previous investigations were conducted in 2007, 2013, 2015, 2017, and 2018. I would note Your Honor, and I won't go into details, because frankly, I think to protect the child's privacy, but there are admissions made by these children when faced with the prospect of being around their mother again, reunited with their mother. They voice serious concerns, physical concerns for their own well-being, Your Honor. I would also note another reason I'm asking the court for a GPS monitor, and for that even if the family court judge permits supervised contact, that the court should not permit any contact until Judge Culver can hear the matter, is there's different interests in a civil matter and a criminal matter. Your Honor, my concern is in ensuring the integrity of the judicial process in this case. Your Honor, this is a filed case, and I reviewed additional reports, and there's an allegation in a sworn report that one of the victims in this case advised law enforcement that when law enforcement, Coral Springs Police, arrived at the home, that Ms. Fuentes Ruiz started telling her, the victim's younger brothers, to lie to the police about what was happening. I have concerns that even given allowed supervised contact, that she could try to influence the victims in this case, who are also the witnesses in this case.
Right.
These are all issues being dealt with in the dependency case. Obviously, we believe that those allegations are false, and that's what's been going on in the dependency case. This is nothing new since the dependent case was filed. This is all alleged acts prior to the dependency case. So there's been nothing since that. And again, she turned herself in. She works. She's not a flight risk. She's not a danger to the community. We're asking for a minimum bond, $2,500 on each count, no GPS, no prior record.
And obviously, the court will be aware that the potential for Ms. Fuentes Ruiz improperly influencing her children's testimony at a later date would not be a consideration for the family court judge, because it's just not a relevant issue on a family court case. It is a relevant issue, though, obviously, in the criminal case, and that would be an issue for Judge Colra to look into and determine how appropriate any further modifications of supervision would be.
All right, thank you, counselors. I hear that there are lots of things going on, but my review at this time and my determinations is based on the affidavits that are presented to me. And based on the four corners of these affidavits, I do find probable cause. And based on what's in there, there are some concerns. So I am going to impose a bond, counts 1 and 2. I'm gonna do $10,000 each with a GPS monitor and no contact with the victims in this case.
And Your Honor, just for clarification purposes, since she has multiple children but only 2.
Oh, just the ones that,
Your Honor, I don't know that I can ask the court to order no contact with the other children at this point because they're not subject to this case.
Yeah, there's
Right.
no jurisdiction.
Those children's initials would be, in this case, EG and DG.
okay. All right, thank you.
Thank
Good
you.
luck, ma'am. Mr. Odom? Yes.
Ask the court to get involved and resolve this case possibly this morning. It has nothing to do, correction, I'm thinking of someone else. We would ask the court to get involved. He's at main facility on page 10.
Wayne Golden is here for a municipal ordinance matter. It's an open container of alcohol matter.
Yes, Your Honor.
Wayne Golden? Mr. Golden, good morning. Sir, you're before the court today for a municipal ordinance open container matter. The court does find probable cause. Mr. Odom, what does he wish to do?
Judge, if the court will consider withhold adjudication in court costs, allowing him sufficient time.
All right. Mr. Golden, do you wish to resolve your case with withhold adjudication and court costs?
Yes, ma'am.
All right. Sir, please raise your right hand. Do you swear affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Sir, do you understand the proceedings that you're in today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Do you need more time to speak with your attorney?
Yes, ma'am.
Do you need more time to speak with your attorney?
Yes, ma'am.
Mr. Golden, I'm right here. She's asking, do you have any more questions for me?
No, sir.
Okay.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that you, if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Okay.
What plea do you wish to enter, Mr. Golden?
No contest?
I accept your no contest plea. You find that it's freely and voluntarily given. Your sentence, sir, will be a withhold adjudication and court costs. I'll give you 6 months to pay your court costs. Good luck, sir.
Thank you, ma'am.
Thank you, Judge. May I be excused?
Certainly. Thank you, Mr. Odom. All right. There is a handwriting that looks like my son on page 21. I don't know what it says.
Can you move on? Not the first time I've heard that.
What is the last name?
Mouton, M-O-U-T-O-N.
Okay.
Don't say anything. Did you hear me, Kenya?
Yes.
Already pulled that out? Thank you. Thank you. All right, Mr. Mouton, sir, you're before the court today for one count of carrying a concealed firearm, 2, possession of a weapon or ammo by a convicted felon, and 3 is a misdemeanor capious matter. Okay? Let me just.
Do you have an attorney? Are you gonna hire your own, or do you want a public defender?
I do find probable cause, this is the parties wish to say.
Judge, I had no arguments relative to probable cause. However, Mr. Mouton is a lifelong resident of Broward County. He has significant family ties. He's not a flight risk. I would just ask for a reasonable monetary bond. That's to counts 1 and 2, maybe $2,000 on count 2, $1,500 on count 1 for an aggregate bond of $3,500. I've represented Mr. Mouton for years. He's going to appear in court. We will defend against these charges and the capious matter as well.
Okay.
I'm going to be requesting a $7,500 bond on count 2. Mr. Mouton has 2 pending felonies, possession of heroin, and the second is possession of cocaine. In 2016,
I can't hear what he's saying.
All right, over at the.
I can't hear what he's saying.
Hold on just a moment. At the main jail.
He's just talking about your pending cases and that are already filed.
There's a lot of feedback coming back, and we need to be able to hear. Thank you. All right.
Thank you, Judge. As I mentioned, he has 2 pending felony drug cases. 2016 grand theft auto and fleeing and eluding, violation of probation, a year and a day state prison, possession of PVP 2015, battery 2011, carrying concealed firearm 2010, violated probation, was sentenced to 5 years state prison, robbery by sudden snatching and aggravated assault, a deadly weapon 2008. Nothing further, Judge.
I would just ask you not to revoke the bonds in the pending cases before Judge Weeks. We are defending against those cases through motions to suppress, and if the state attorney in the division files a motion to revoke his bond, Mr. Mouton will appear and we'll deal with it before Judge Weeks at the appropriate time. But I would ask you just to set a bond in the new charges and allow him to remain on the bonds in the pending cases until such action, if taken, is done before the division judge.
All right. As to count 1, carrying concealed firearm, the bond will remain in place at $1,000. On count 2, the bond will be $3,500, and then the misdemeanor capious, which was previously set, is a $500 bond. Good luck, sir.
Thank you, Judge.
Yes, 3,500. All right. Bill Alcius, have you been able to speak with him? Bill Alcius, he's on page 31. Have you had an opportunity to speak with him already, Mr. Romero?
Yes, Judge.
He has family here that signed in, so earlier.
I'm ready to proceed.
All right. Mr. Alcius, you're before the court today for 1 count of touch or strike battery, 2 is a battery on an officer or firefighter, and 3 is trespassing occupied structure or conveyance. The court does find probable cause. Does the parties wish to be heard as to bond?
Your Honor, based on the totality of the circumstances, I'd be requesting a $2,500 bond on count 2. No return to the Party City on Oakwood Boulevard in Hollywood.
Judge, the court did say, I believe, that Mr. Alcius had family there. We don't see his family.
Someone signed in. I don't know who's there. Someone signed in.
Oh, there's.
Good morning. You're who, sir?
He's my brother.
You're his brother? Okay. Is there something that you wish to say? All right. Okay.
Judge, in speaking with Mr. Alcius, first he appreciates that his brother's there, lending moral support. Having said that, Judge, my understanding is speaking with Mr. Alcius, he has a clean record. He's 23 years old, been living in our community since 2001. Mr. Alcius is working. He works for a company called Teleperformance, where he's making $13.50 an hour, in customer service. Now, he lives with his mother. She is a single mother, and she's basically raising him and his 5 siblings. That's something that he's going to be relying on to post a monetary bond. First, of course, Judge, because he has a clean record, I'm first going to ask the court to consider releasing Mr. Alcias ROR. If the court is not in agreement with me, then I'd be asking the court to consider setting a bond of $1,000 on count 2, which is a third-degree felony. Speaking of Mr. Alcias, I have no doubt that he'll be returning to face these allegations in court, but we're going to be asking for a $1,000 bond on count 2, Judge.
In addition, Judge, his mother is also present.
Okay.
Just note, Your Honor, this whole thing started because Mr. Alcias and his co-arrestee, who we'll have later in the docket, forced their way into this store without permission while it was closed, and even the other employees advised law enforcement they were in fear when both co-defendants forced their way into the store.
Okay, the court does find probable cause, and based on my review of this probable cause affidavit, I am going to impose a bond on count 2 at $2,000, and I believe that's a reasonable bond. As to counts 1 and 2, counts 1 and 3, no bond is required, so I will not impose a bond on those counts. Good luck, sir.
Thank you, Judge.
All right.
Spanish interpreter is present, Judge.
All right. What do we know, what case is needed?
Judge, I believe it was on page 19. The gentleman's name is
Sotolongo.
Mr. Sotolongo. Diane Sotolongo. Señor Sotolongo. Ven, por favor.
Page 19.
Do we know if there's anyone else that will need the Spanish interpreter?
Not here at Maine, Judge. I don't know if the other facilities.
Okay. All right, Madam Interpreter, can you please raise your right hand? Do you swear or affirm to translate from Spanish to English and English to Spanish?
I do. Alicia Stegmuller.
Can you tell me, what's your last name again?
Stegmuller.
Stegma. Good morning, Mr. Sotolongo.
Buenos días, señor Sotolongo. Good morning.
Sir, you're before the court today for, one, a felony capias matter.
Está aquí para un orden de arresto de delito mayor.
It is a no bond hold, not for magistrate.
Hay una detención sin fianza que no es para el magisterio.
And then on count 2 is a misdemeanor capias.
Y por el segundo cargo es un cargo menor de delito menor.
And there is a bond that's assigned of $500.
Y es una fianza de $500.
You should be going to Division FF tomorrow at 8:30.
A las 3:30 mañana usted va a ir a la división FF.
And you're due before the misdemeanor court on February 18th at 8:30.
Y a las 8:30 el 18 de febrero va a estar delante del Tribunal de Delitos Menores.
Good luck, sir.
Buena suerte, señor.
Is there anyone else who needs a Spanish interpreter?
No one else at Maine, Judge.
Thank you. Thank you. All right. Is Harvey Singleton represented by the Public Defender's Office? And has the Public Defender on page 26?
Thank you. Let me look, Judge. 26. Harvey Singletary. Judge, she's here present, and I've had an opportunity to speak to him. So whenever the court's ready, we may proceed.
All right, thank you. So Harvey Singleton. Mr. Singleton, you're before the court today for 1 count of aggravated stalking, 2 intimidation, rights under threat to kill or injure, and 3 touch or strike battery.
We do not represent Mr. Singleton on this case as of yet, Judge. And I don't believe I've had a chance to review the PC sheet because it's not yet in Odyssey, if I'm not mistaken.
All right,
So read.
I can recall it, you know. I'll have to recall Mr. Singleton's case.
Thank you, Judge.
Evangelina Duncan.
Evangelina Duncan.
How long are you looking for?
North Broward, Judge.
Thank you. Ms. Duncan, good morning.
Good morning.
Ma'am, you're before the court for 1 count of grand theft,
Yes, ma'am.
2 fraudulent use or possession of ID of another person, and 3 possession of a blank or unlawfully issued driver's license. And the court does find probable cause. Does the parties wish to be heard?
Yes, Your Honor. I'm going to ask the court to consider releasing Ms. Duncan on ROR with pretrial release. She's been a resident of Florida not long, only 8 months, but she does have a place to stay at Camilla House. She has a job working in a labor pool for hire in Dade County, making $13 an hour. And from what I understand, her prior criminal record is not very extensive at all. So based on that, I'd ask the court to consider allowing her out on a pretrial release.
Your Honor, I'd be opposing pretrial release. I'm actually going to be requesting a bond amount of $5,000 on count 1. I believe considering the specific facts in this case, a $7,000 bond is quite appropriate. Considering that she withdrew $7,000 from the victim's account at another bank before trying to withdraw $7,500 from the victim's account at another bank, and that's what she was arrested on. So there's $7,000 cash out there that's unaccounted for. She really has no ties to the community. Residing at Camilla House, she could leave there at any time. She was just arrested, it looks like last year in Missouri for felony check fraud.
That was dropped.
Just about to say it was dropped, Your Honor. The reason I'm bringing it up is it shows that she, it would appear that she is transient, Your Honor. She's, in this case, in possession of, one moment, an ID that was stolen just a week prior in Dade County. And I have concerns about her future appearance in court, and frankly, I have concerns about what's being represented about her financial means.
All right, ma'am, you don't want to say anything, okay? I do find probable cause, and based on the circumstances in this probable cause affidavit, there are concerns. As to count 1, I will impose a bond of $5,000. Counts 2 and 3 will be $1,000 each. Good luck, ma'am.
Your Honor, I'll be requesting no contact with Anika Suklal.
What does that mean?
Tell me the name again.
Anika Suklal. Ma'am.
And
Oh,
Ms. Duncan, come back. And no contact with the victim in this case,
Okay.
as you heard.
right.
All right, good luck, ma'am.
So what's going to happen? I don't understand, sorry.
You have $7,000 worth of bond. Your attorney will speak with you in further.
Okay.
Tamara Chin.
She is here, present, Judge at Maine. Judge, Ms. Chin, under service of public defender.
Ms. Chin, good morning.
Good morning.
Ma'am, you're before the court for 1 count of grand theft auto, and I do find probable cause. Statements to be heard as to her bond.
wasn't gonna be asking for any modification.
All right. Ms. Chin, your bond is $1,000. Good luck.
Yeah.
Good luck. Elizabeth Dobbins.
Dobbins is in North Broward, Your Honor. I think. Wait a minute. Yes, she
Yes.
is. She's in North Broward.
Ms. Dobbins, good morning. You're before
Yes.
you're before the court today for one count of prostitution, and the court does find probable cause. What does Ms. Dobbins wish to do?
Judge, I spoke with her son about the possibility of raising $1,000 in bond. He's at work right now, so we really didn't have much of a chance to have too much of a discussion about it. But I got the impression that he might not be able to do it. I think they just had a child in the family, and there's a lot of financial considerations in that regard. Ms. Dobbins has been living here all of her life. She does have an address where she can stay. And I'd ask the court to consider an ROR on this charge.
Your Honor, I wouldn't have objection to pretrial, but she does have a lengthy history involving drugs and prostitution.
All right, I do find probable cause, and I will release Ms. Dobbins' standard pretrial supervision. Good luck, ma'am.
What does that mean?
It means, Ms. Dobbins, that you're going to be released, but you have to check in with pretrial release within 24 hours of getting out of jail, okay?
Thank you.
Okay, I suggest you call your son as soon as you get out.
Oh, I will. I'm gonna be a grandma.
Okay, congratulations, Ms. Dobbins.
All right, Terrence Walker.
Mr. Walker is in North Broward. I'd like to resolve this case this morning.
Good morning, Mr. Walker. You're before
Good morning, Judge.
you're before the court for trespassing, failure to leave property. And I do find probable cause. Your attorney tells me you wish to resolve the case.
Yes, ma'am.
State, did you have an offer for Mr. Walker?
Yes, Judge, adjudication, court cost, time served, no return, please.
Is that what you'd like to do, Mr. Walker?
Yes, sir.
All right, Mr. Walker, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand the proceedings that you're in today?
Yes.
Do you need more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of alcohol or drugs?
No.
Do you understand that you have the right to go to trial, that by taking a plea today, you're giving up that right?
Yes.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Walker?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. Sir, no return to the business called You Save at 4039 Northwest 19th Street in Lauderhill. Good luck, sir.
Thank you.
You're welcome. Michael McCray,
North Broward, I believe, Judge.
medical reset. Thank you. How about Risto Goznadov?
He's here, present, Judge, at Maine.
Good morning, sir. You're before the court for one count of petty theft, and the court does find probable cause. What does he wish to do?
Judge, Mr. Grosnoff is looking forward to contesting these allegations. I do realize it's a $25 bond. I don't know if the court would be inclined to ROR Mr. Grosnoff. If not, then I'm going to ask the court to sign a phone order so he can access his phone contacts, so he can call his friends and family to post his monetary bond.
All right, I will ROR. Good luck, sir. All right, Alton Harris.
Your Honor, Mr. Harris is in North Broward. This is a municipal ordinance case. Mr. Harris is speech impaired.
I do remember.
He has written out for the deputy a communication with the court indicating that he would like to resolve the case today and is able to answer questions, and I've asked if the deputy would consider reading that to the court at this time.
Okay, Deputy, thank you.
I would like to resolve today, please. It's only an open container charge, and I will raise my hands to answer all questions. Right hand for yes, left hand for no.
All right, thank you. Mr. Harris, you're before the court today for a misdemeanor capias. It's as you stated, an open container matter. It's a municipal ordinance matter as well. What city is this? Okay, Mr. Harris, if you wish to resolve your case today, the sentence will be a withhold adjudication and court costs. Do you wish to resolve your case with that? All right, sir. Then your sentence, sir, will be withhold adjudication and court cost, and I will give you 6 months to pay the court cost. Good luck. You're welcome, sir.
Joseph Gramanzini?
What is, I don't even, what is the name?
Gramanzini. He's had a couple of cases before Mr. Harris.
I don't know.
Yeah, Joseph is easy.
It went to domestic.
The what?
It went to domestic.
Oh, okay.
All right. William Williford.
He's here present, Judge Amain.
Mr. Williford, you're before the court for 3 counts of traffic capias. And the court does find probable cause. It looks like your suspended driver's license matters, that you failed to appear in court. This is since 2017. So what does Mr. Williford wish to do?
Mr. Wilford has asked me to ask the court if the court would release him on pretrial release, Judge.
All right. I do find probable cause, and I'll release Mr. Williford to standard pretrial. Good luck, sir.
Thank you.
You're welcome. All right. Mr. Reedy, when you're ready with Singleton, you can let me know. And there's, I'm just gonna ask that, when it's not an attorney who signs in, if somebody just checks in to see if the public defender represents them. Joseph, Urias Joseph on page 23, Mr. Reedy.
23.
Do you know, not yet, ma'am,
Right.
I'm just trying to determine,
Mr. Urias Joseph on page 20, Judge. I've spoken to him, and I believe he's filled out an application for a public defender.
all right, so then, at this time, let me call Harvey Singleton, who's on page 26.
On what page?
26.
26. Mr. Singleton is here present, Judge.
All right, Mr. Singleton, you're before the court for 1 count of aggravated stalking, 2, intimidation, right or send threat to kill, and 3, touch or strike battery. And the court does find probable cause as to all those counts. Does the parties wish to be heard as to bond?
Your Honor, I'm going to be seeking a, a $35,000 bond on counts 1 and 2, pretrial release with a GPS monitor, that Mr. Singleton, obviously no victim contact, that Mr. Singleton not be in possession of any firearms, weapons, or ammunition until further order of the court. I'm greatly concerned for not only the victim's safety, and now that I think about it, I'm also going to ask that the no contact order also apply to the victim's family. I'm concerned that Mr. Singleton has made threats to harm and kill the victim, her child. He has made specific threats as far as the manner in which he would harm and kill these people, even the location. One moment, Judge. She's been sent text messages of pictures of her vehicle from behind, indicating that Mr. Singleton was following her in public. There's even been threats to rape the victim's daughter. Your Honor, I believe the bond and release conditions the state is requesting is necessary to ensure the safety of the victim and her family. I would also note, as far as Broward, Mr. Singleton in 2013 was convicted of strong-arm robbery, violated probation, was sentenced to 1 year and a day state prison. He also, 2013, I won't go into that. Just want to note. Your Honor, I think the court should also be aware in 2018, a separate individual sought and obtained an injunction order of protection against Mr. Singleton.
All right, Mr. James?
Yes, ma'am. I'm here on behalf of his sister, Ann Aquanica. And she spoke with the family. I think the most they can come up with is 10,000, which is 1,000, 10%.
And Judge, I would go that, the same request, I was gonna ask for 5,000 on 1, 5,000 on 2, 1,000 on 3, total bond 11,000. I was gonna ask the court to consider, we don't object as far as Mr. Singleton being supervised, but we're gonna be asking for standard pretrial release. In speaking with Mr. Singleton, Judge, there are two sides to the story. I did tell him today's not the day to litigate and argue his side. He will have a chance in the future to do that. But he's 25 years old, been living in Florida his whole life. He is working right now. He works at Paramount Training Services. He's a CNA instructor, getting paid about $12 an hour. And the person who he advised me from the beginning that was going to help post his bond is his sister. And he believed that his sister, same thing, would be able to afford if the bond was set at 5 on 1, 5 on 2, that maybe she would be able to come up with that. Besides that, Judge, he is attending Palm Beach State University, where he goes to school from Monday through Thursday. Now, we don't have an objection, Judge, as far as the special conditions that the state requested, as far as no contact with the victim or no contact with the victim's family. But right now, financially, from what Mr. Singleton and what's just been reaffirmed, the most that his family is going to be able to come up with is 10,000. So I'm asking for a total of 11,000 plus standard pretrial release, Judge.
Your Honor, I just want to advise the court, I now found another individual in 2017 that sought and obtained a temporary injunction order of protection against Mr. Singleton. So now, just in the past 2 years, there's a total of 3 different people that have felt necessary to go to court to obtain temporary injunctions and injunctive relief for their safety against Mr. Singleton.
Great, thank you. In reviewing the probable cause affidavit, I do have great concerns for the community. I do find probable cause. As to count 1, I am imposing a bond of $50,000. Count 2, $50,000. Count 3 will be $1,000 with pretrial release GPS. No firearms, no contact with the victim, Shade Johnson, or her family. Good luck, sir.
Thank you.
All right, and then I'll call on page 23, Urias Joseph. Did I pull that?
He's
one?
approaching, Judge.
Okay, hold on, I thought I pulled that one out. All right. Good morning, ma'am. Mr. Joseph is before the court today for one count of trafficking cocaine, 28 less than 200 grams, and then using a two-way communication device to facilitate the felony. And the court does find probable cause as to those two counts, and the parties wish to be heard as to bond.
Your Honor, I'm going to be requesting a $75,000 bond on the trafficking, a $10,000 bond on the use of a two-way communication device to facilitate a felony. I'm going to be asking that the special release conditions that Judge Lynch set be kept in place as well. I would note, in addition to these charges, Mr. Joseph has a pending possession of cocaine, PVP, and alprazolam with a resisting without violence. He has prior convictions for, in 2010, possession of cocaine with intent to sell or distribute, 2 years state prison. 09, possession of cocaine, 2 years state prison. 06, fleeing and eluding possession of cocaine, introduction of contraband into a detention facility, 22 months state prison as a habitual offender. 05, possession of cocaine, 22 months in state prison. 01, possession of cocaine, just under 26 months. 02, delivery of cocaine and possession of cocaine with intent, 25 months state prison as a habitual offender. 97, sale delivery of cocaine within 1,000 feet of a school, 3 years state prison. Strong arm robbery, 96.
The $85,000, which the state is suggesting, is just something financially impossible for Mr. Joseph or his family at this time. He's 40 years old, been here his whole entire life. Right now, unfortunately, he was working at the car wash. He suffered an injury, and now he's doing the paperwork necessary in order to apply for disability. He lives in Lauderhill with a friend. His friend is one of the people he's going to be reaching out to post his monetary bond, works in landscaping. He appreciates his girlfriend being here. My understanding is she's a hairstylist. Just from what he's advised me, his friends and family just do not have the financial resources to come up with $85,000. Now, Mr. Joseph did record, and you heard it from the state, but I believe he's been clean and out of trouble with our criminal justice system for over a year. From what Mr. Joseph advised me, he owns no property. He has no money in the bank. He doesn't have a vehicle or car, no collateral to even come up with to try and post a monetary bond, Judge. I'm going to be asking you to take that into account in determining reasonable release conditions for Mr. Joseph.
Your Honor, I would just note, considering that this deal was allegedly involving an amount of for $2,000 in cash, and with his history of dealing, I don't know that the court can take at face value what his financial abilities are at this time.
All right, ma'am, is there something you wanted to say? No. Okay. All right, Mr. Joseph, I do find probable cause as to counts 1 and 2, trafficking in cocaine and using a two-way device to facilitate the felony. As to count 1, I am going to impose a $75,000 bond. And on count 2, $10,000, along with the special conditions that are attached to the warrant to arrest that was delineated by Judge Lynch.
Your Honor, I just want to clarify, because Judge Lynch, he signed off where it says the defendant will be monitored by pretrial services. My interpretation, when the use of the word monitor means a GPS.
Which number are you talking about?
Number 4 on the special bond conditions.
Right, so all the special bond conditions imposed.
I'm sorry, the reason I'm inquiring is it doesn't specifically say GPS monitor, but my
Yes.
understanding when it says monitor, that's
GPS.
All right, thank you.
Judge, would you consider deleting pretrial with GPS considering the high monetary bond on these offenses?
No, that will be denied at this time. Thank you. Christopher George Bell. Thank you, ma'am.
I've been informed he bonded.
All right. Jonathan Baez.
Mr. Baez, it's here present, Judge, at Maine.
Mr. Baez, you're before the court for 3 counts of misdemeanor capias. The court does find probable cause. There are 3 drug paraphernalia, driving while license suspended, leaving the scene of an accident. Does the parties wish to be heard as to bond?
Your Honor, considering that Mr. Baez's prison sentence is set to expire today, if he's interested in resolving the matter, the state's offered being adjudication time served on all counts.
He wishes to accept the state's offer, Judge.
All right, Mr. Baez, please raise your right hand. Do you swear or affirm to tell the truth, sir?
Yes, ma'am.
All right, do you understand the proceedings that you're in today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to go to trial, that by taking a plea, you're giving up that right?
I did not hear what you said, ma'am. You just cut out the last sentence.
You have a right to go to trial, so by taking a plea, you're giving up that right.
Yes, ma'am.
All right. Have you ever been treated for mental or emotional illness?
No, ma'am.
All right. What plea do you wish to enter, Mr. Baez?
Guilty.
All right. I accept your plea. I find that it's freely and voluntarily given. I sentence you to adjudication and time served. Good luck, sir.
Thank you, ma'am.
All right. Timothy Odom.
He's approaching, Judge. He's here at Maine Municipal Ordinance.
Madam Clerk, do you know how we can transfer cases to the community court? I'm sorry? Okay, all right. All right, Mr. Odom, you're before the court for a municipal ordinance matter. And I do find probable cause, but I wanted to, Mr. Odom, do you know about the community court on Wednesdays? Have you ever?
No,
Have you? All right. Mr. Reedy, do you know how I can transfer a case to community
It's all
court?
kind of new to me, Judge. I really don't know as of yet.
Your Honor, if you want to maybe reach out to Judge Barner.
Yeah, I know, but I don't have her. Do you know her?
Get it.
7-5.
Parang paano pretrial? Any cases? You live alone with family, your friends? Parents? Your parents?
Hi, good morning, Yvette. It's Judge Powell. How are you? I'm fine. Listen, if I have a case in front of me this morning, it's magistrate court. that I would like to transfer to community court. Do you know what the procedure is to get that done? Mhm. Okay, all right.
Also, I thought the, it was at City Hall. Your Honor, I don't know if you want to confirm if they only handle Fort Lauderdale cases or other municipalities.
Yeah, I'll find out. Are you able to ask her about the city?
She said that, McLaurin's and that other young lady that.
Yeah, but which,
Yeah, but I told her when none of them here, so she said if you just send her name, she'll be the.
yeah, but thank you, I appreciate it. Yes. Yes. All right, thank you. All right, okay. All right, Mr. Odom, if you'll hold on a minute, I'll recall your case, okay? I'm gonna recall you, just have a seat for a moment. Adesh Prasad,
Mr. Prasad is here, main judge approaching.
Mr. Prasad, you're before the court for a misdemeanor capious matter. Trying to find the page, and the court does find probable cause. It is.
Judge, I believe we have something similar. Mr. Prasad advised me that his EOS date was actually on February 7th. This is the only thing holding him in custody. He was serving a sentence, I believe, since 2017 till this year. I do realize it's a battery. I don't know if the state, maybe within their notes, had an offer from the prior prosecutor that was assigned to the case.
No, I don't have an offer at this time on the battery.
I understood. I advise Mr. Prasad it's going to be difficult to try and resolve a case like this. But I'm going to be asking if the
Mr.
court.
Romero, hold on. There's a alarm.
Ladies and gentlemen, we ask that you rise for a moment of silence. On February 14th, 2018, we tragically lost 17 members of our Broward County community at Marjorie Stoneman Douglas High School in Parkland. In honor of their memory, we ask that you join us in observing 17 seconds of silence for the victims of this tragedy. Thank you.
All right, Mr. Romero, I'm looking at these, keep this.
I see there's a $500 bond. He's not going to be able to afford it, Judge, considering he's been in custody. I think he's actually, like his release was February 7th, so he's been an extra week. I'm going to be asking for the court to consider releasing Mr. Prasad Arwar on this matter,
Are you
Judge.
saying he was is it serving a sentence and that the sentence is up when?
It was last week on February 7th, so then he was transported here to deal with this matter since he was in custody.
Okay. All right, I'll ROR Mr. Prasad on this matter.
Thank you, Judge.
He needs to make sure that he, check his mail and know when he's gotta report to court.
Thank you, Judge.
Thank you. Judge Brenner, thank you. I just wanted to check to see, do you only take Fort Lauderdale cases?
Yes,
Ah,
has to be in Fort Lauderdale and no priors of violence.
okay, all right, this one's out of Pompano, so. All right, thank you. Thank you for coming, you didn't have to come down. Okay. All right, Mr. Odom, can you come back up, please? Mr. Odom, I was attempting to see if I could get you into community court, but the city, is not yet participating in that project. So, what do you wish to do with your case, Mr. Odom?
No contest.
And, the reason why I was attempting to get you into this program is because you've now been before me 2 times for this. And last time we had this conversation, you told me that, we were not going to have this conversation again, but we are here again.
My girlfriend was released and she went back up to Pompano and I had to go up there and try to get her. In the meantime, same old thing happened Look, can you guys get me into a rehab, put me in somewhere? I mean, really.
Well,
Get me off the
that's
street.
something that you're gonna have to work on.
I've been working on it and
Do we have any referrals for Mr. Odom?
I'm going to jail 5 times a week now.
Well, that's why I asked you last time to stay out of Pompano, because this is what happens. But, if you want to resolve your case today, it's gonna be adjudication and time served, but how can I get you to stop coming back, Mr. Odom? You're gonna have to find a program to get in, if you have nowhere to stay.
All right.
All right. Raise your right hand, Mr. Odom. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. Do you understand the proceedings that you're in today?
Yes.
And is anyone forcing you to resolve your case?
No.
Do you need more time to speak with an attorney?
No, ma'am.
And, are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that you do have the right to go to trial, but taking a plea today, you're waiving that right? Do you understand
Yes,
that?
ma'am.
Have you
Yes,
ever been
ma'am.
treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea could, subject you to deportation or immigration changes?
Yes, ma'am.
All right. Mr. Odom, what plea do you wish to enter?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and I'm sentencing you to adjudication and time served.
Thank you, Your Honor.
Mr. Odom, can I tell you again that you need to find a program to get into when you get out? And you can't keep going back to Pompano, where you keep getting arrested.
There's not too many cities I can go to now.
There are lots of cities in Broward County.
I'm banned from all of them, almost.
All right, good luck, Mr. Odom.
Thank you.
Michael Cade?
He's approaching, Judge. Bringing his phone.
Yes, please, madam. She just said, I
I gotta do this first because I'm waiting.
Mr. Cade is another. Mr. Cade,
Yes, ma'am.
How many? Do you work? What'd you
Mr.
say?
Cade, you're before the court for municipal ordinance matter
Listen to me.
out
Yes,
of,
ma'am.
out of the city of Pompano.
You get assistance from the government?
Yeah, ma'am.
And last week when you were here, the last time you were here, I sentenced you to 5 days, and you told me that that was a lot of time for a municipal ordinance charge.
Yes, ma'am. I asked for a cigarette and they said it's soliciting.
But I told you not to go back to Pompano last time.
Oh, this wasn't the same area, ma'am.
Okay.
But it's still pumping up, ma'am. Yes, ma'am. Yeah.
Right.
Yes, ma'am.
So, what are you gonna do different next time?
Well, ma'am, I think I might stay down here downtown for a little while. There's a shelter down here, and I might head down here and try to get some directional infiltrates. But I do have a PE missionary down in Pompano, so I have to avoid my time down there.
Well, you may want to go to the shelter in Fort Lauderdale, like you said.
Yes, ma'am.
All right. If you want to resolve your case today, Mr. Cade, it's going to be adjudication and time served. Do you want to do that?
Ma'am, I do, ma'am.
Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Do you understand what you're doing today?
Yes, ma'am, I do.
And are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that you have the right to go to trial? But by taking a plea today, you're giving up that right.
Yes, ma'am, I used to do.
Okay, and you understand if you're not a U.S. citizen, that by taking a plea, you may be subjected to deportation or immigration changes.
Yes, ma'am.
Do you need more time to speak with an attorney, Mr. Cade?
No, ma'am, I do not.
What plea do you wish to enter?
Yes.
All right, Mr. Cade, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. I'm gonna give you 6 months to pay your court costs.
Yes, ma'am.
All right, and I hope not to see you in this place again.
Yes, ma'am.
All right, good luck.
Thank you, ma'am.
All right, can we go back? Antonio Trujillo.
Mr. Trujillo is here, present, Judge at Main, approaching.
Sir, good morning. You're before the court from, it's a misdemeanor KPS. You're brought before the court. It's on a battery charge. You failed to appear in court last September. I do find probable cause. What does Mr. Trujillo wish to do?
Nothing at this time, Judge.
All right, sir, your bond is $250. Good luck. Derek Sensor.
He's here, approaching, Judge at Main. Come on up, sir.
Mr. Sensor, you're before the court this morning for trespassing, failure to leave. And the court does find probable cause. What does Mr. Sensor wish to do?
Judge, in speaking with Mr. Censor, he wishes to ask the court if the court would consider resolving this matter today.
Does the state have an offer for Mr. Sensor?
Yes, Judge. The offer is withhold court costs, no return.
Sir, do you understand that offer?
He wishes to accept its offer, Judge.
All right. Mr. Sensor, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down, sir.
All right.
Do you understand the proceedings that you're in today?
Yes, ma'am.
And do you need more time to speak with your attorney?
No, ma'am.
Are you under the influence of alcohol or drugs?
You just cut off, Judge, the whole sentence.
Are you under the influence of alcohol or drugs?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that you have the right to go to trial, that by taking a plea, you're giving up that right?
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right. Mr. Censor, what plea do you wish to enter this morning? Guilty or no contest?
I said no contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence, sir, will be a withhold adjudication and court costs. Good luck. Ricardo Florestal.
Mr. Forrestal is here present at main, Judge.
Mr. Florestal, you're before the court today for one count of resisting without violence, resisting officer without violence, 2, trespassing occupied structure or conveyance.
Judge, and speaking Mr. Forrestal, I'm going to be asking the court to consider releasing Mr. Florestal ROR. I don't know if the state has an objection to that.
I don't, Your Honor. Just ask for an order of no return to Party City.
I'm sorry, what was Mr. Romero asking for?
ROR.
All right, the court finds probable cause RR, Mr. Florestal. Good luck, sir. Jeffrey Ories.
Mr. Ories is here present, Judge, at main.
Mr. Ories, you're before the court for one count of possession of cannabis, 20 grams or less, and 2, operating without a valid driver's license. The court does find probable cause.
Judge, Mr. Ories is asking if the state has an offer on this case.
Withhold court costs on both counts.
Mr. Ories, the offer from the state is a withhold adjudication and court costs. Do you wish to resolve your case with that plea offer?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down, sir. Do you understand the proceedings that you're in today, Mr. Ories?
Yes, ma'am.
And do you need more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
Mr. Ories, what plea do you wish to enter today, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. I sentence you to a withhold adjudication and court costs on both counts. Good luck, sir. Davion Ridge.
Medical reset.
All right. Jeremiah Johnson.
Conti, Your Honor.
Okay.
Mr. Johnson did not want to join us this morning.
Okay. All right. So I will, does he want to join us this afternoon? Do you know?
I just called the unit again, and he flat out said I refuse.
Well, if he, I'm gonna reset him for the afternoon. If he doesn't want to join us, I will make these findings without him.
Yes, ma'am.
All right. Thank you. Michael Tavares Carrero.
Yes, ma'am.
Where is Mr. Carrero?
Right here.
North Broward.
All right. Mr. Carrero, good morning. Sir, you're
Morning.
before the court for 1 count of possession of methamphetamine, 2, possession of cocaine, 3, possession of cannabis 20 grams or less, 4, possession of drug paraphernalia, 5, driving while license suspended, first offense, and 6 is a traffic infraction not for magistrate, and 7 is a violation of felony probation where there is a no bond hold. So my notes indicate, sir, that you should be going to your division felony judge FG tomorrow at 8:30. I will leave the bonds in place. As to counts 1 and 2, it's $1,000. Counts 3, 4, and 5, it's $100. Good luck, sir. Cameron Hamilton. Cameron,
Mr. Hamilton has private counsel, Judge.
I spoke with Mr. Glassman, Your Honor. In fact, Mr. Glassman actually was
he
here.
was here.
He does not represent Mr. Hamilton on these new charges. He has not yet been retained.
Okay, so Mr. Hamilton, Mr. Glassman, he was in the courtroom this morning. He said he's not been retained on this case.
We're ready to proceed, Judge.
All right, Mr. Hamilton, you're before the court today for 1 count of grand theft auto, 2, resisting officer without violence, 3, fleeing and attempting to elude law enforcement, 4, operating without a valid license, 5, 6, and 7 are felony violation of probation matters where there's a no bond hold. The court does find probable cause. As to the felony matters, sir, you'll be before your division judge FX tomorrow at 8:30. And the bonds, the bonds will remain as stated, 1,000 on 1, 100 on 2, 1,000 on 3, and 25 on 4. Good luck, sir. Alfonso Forrester.
Forrester is approaching, Judge. He advises he has private counsel, Miss Lauren Chacoma.
All right, Mr. Forrester, do we know him?
Her listing on the Florida Bar website, there's a phone number that starts 000. So I really was not able to get a hold of her, unless Mr.
Forrester, do you know Mr. Kuma's number?
Mr. Coma?
Yes, do you know her phone number?
No, ma'am.
When was the last time you spoke with her?
My girl spoke with her last night.
And what did she tell you? As to her retaining, you retaining her. Did they pay her to be here today? Do you know?
I don't know.
All right, hold on just a moment. Turn off your speaker there, mister. 954 524 1717.
Thank you for calling the Law Office of Laura Chakuma. Please remain on the line for the next available representative. Good morning, the Gifford County Law Office of Large Tacoma. My name is Susie. How may I assist you?
Good morning, Susie. This is Judge Jackie Powell, and I'm calling from open court and a magistrate court. I have a gentleman before me this morning. His name is Alfonso Forrester, and he tells me that he's represented by your attorney.
Okay, is Alfonso Forrester?
Forrester. Forrester.
Okay, and what is your name, ma'am?
This is Judge Jackie Powell, and I'm in open court.
Okay. Give me a brief second, okay?
Okay?
Thank you for holding. We sincerely appreciate your patience. Please stay on the line, and we'll be back with you in a moment.
I think it's female. Someone that had it. Where's the, do we have the paperwork?
Okay.
Shelby, do you have the warrant affidavit? It's in here. What happened is in our system. Can you copy?
Thank you for waiting. Your patience is appreciated. Please hold the line, and we'll be right back with you.
Sorry about the hold, Judge Jackie.
Yes.
Yes, I wasn't able to get a hold of her. Would you like to leave your name and number so she can give you a call back?
Well, no, I was just trying to accommodate this process. Like I said, I have this gentleman before me this morning, and he says that she represents him. So it's first appearance.
I won't be.
All right, well, I'll just have to let him
I
know.
won't be able to confirm that.
All right, thank you very much, ma'am. Thank you.
You're welcome.
All right, bye-bye. All right, Mr. Forrester, that was her office. They are not able to confirm that she's been retained and she's not in the office. So you have the option this morning, sir. You do have an attorney over at the main jail if you wish to.
Do it now.
All right, well then, maybe they need a few minutes to speak with you. All right, Alfredo Castellon.
He's here, present judge at Maine.
All right.
Good morning.
Good morning, sir. You're before the court today for one count of burglary with assault or battery, 2 touch or strike battery, and 3 tampering in misdemeanor proceeding. And I do find probable cause as to all 3 counts.
Your Honor, I'm going to be seeking a no bond hold on count 1. Upon a finding of proof evident or presumption great for first appearance purposes. Your Honor, I'm relying upon the probable cause affidavit. I would also note that the physical evidence, the victim's injuries, and also the damage that officers observed at the where Mr. Castellone unlawfully entered the residence, noting that the window screen was pushed in and the window crank removed, would corroborate the victim's allegations. I also have concern for the victim's well-being, noting Mr. Castellone, while in police custody, made threats towards the victim, stating he was going to go back and beat the F out of would appear that he's referring to the victim, since he's going to jail anyways.
Your Honor, we would object to the court making a finding of proof evident presumption great at this stage of the proceedings. That's the highest standard of proof we have in the criminal justice system. All the court has been provided with this morning is a rather one-sided story written by an officer to justify the charges for which Mr. Castellan is being detained. The state's called no witnesses, introduced no evidence. The victim has not testified before this court, so this court cannot make a determination as to her credibility. If the state wants this court to impose the most severe restriction of pretrial detention, and that is no bond, our position is that they should have to do more than just introduce a probable cause affidavit. Furthermore, if the court does, over our objection, find proof evident presumption great, we would ask the court to exercise its discretion and set bond for Mr. Castellan.
Just note, Your Honor, this is not a one-sided report. The officer included Mr. Castellan's claims that he had permission to enter, that he had a key, he just didn't have it on him. The officer could have left that out if she so chose, but she didn't. That being said, I don't believe there's a lot of credibility to his claims, because if in fact he had permission and resided there, why would he unlawfully force his way in through a window, removing a window screen, and not just knock on the door to be allowed in?
We only have the victim's testimony. We don't even have the victim's testimony. We have an allegation as to what she was told, what someone else was told to Officer Mata, and we don't know if there was a key. If he did have a key, then there's not proof evident presumption great. There might be probable cause, but it's not proof evident presumption great. It doesn't rise to that very high legal standard. And again, I would ask the court to set bond for Mr. Castellan.
All right, thank you. Again, in reviewing the probable cause affidavit, I do find probable cause. Further, there is a great concern for the safety of the community, based on the allegations that's presented before me, and that's what I need to use to make a determination of probable cause. I am also further preliminarily going to find that proof evident presumption great. That is, of course, without prejudice. And as to count 1, Mr. Castellan will be held no bond. On counts 2 and 3, the bonds are $1,000. And also, if no victim contact, and that is by phone or text or email or third party, no contact. Do you understand, sir?
Yes, Your Honor.
All right, good luck, sir. Tyler Mazard.
Mr. Mazard is approaching, Judge. He has private counsel, Mr. Jonathan Meltz.
Mr. Mazard, good morning, Mr. Meltz.
Hi, Judge. Good morning. You don't have to call me. I'm here.
Thank you for being here. Mr. Mazard, you're before the court today for one count of, it's a felony KPS, and then 2 is a misdemeanor KPS. Count 1 is a no bond hold, not for magistrate, and count 2 has a $250 bond attached to it. And Mr. Meltz, Mr. Mazard should be in court tomorrow in Division FD. I don't know which judge that is.
It's Judge Duffy.
At 8:30.
Very good, Judge.
Okay.
See you tomorrow, Mr. Mazard.
Good luck, sir. You're welcome.
Thank you.
Garvin Duncan.
Mr. Duncan, come on up, please.
Mr. Duncan, you're before the court for one count of, it's a misdemeanor KPS, and 2 is a felony violation of probation, and 3 is also misdemeanor KPS. The count 2, the violation of probation, is a no bond hold, and my notes indicate you should be before your division judge as well tomorrow at 8:30. On the misdemeanor cases, your due in court on February 18th at 8:30. The court finds probable cause and will leave those in place. Thank you. Alejandro Gonzalez Davis.
Here, Maine. Order.
Good morning, sir. You have one count of, there's a felony KPS and there's a misdemeanor KPS as well. Count one is a no bond hold not for magistrate, and count two does have a $250 bond. And you should be in court tomorrow and Monday respectively. Tomorrow on the felony cases, Monday on the misdemeanor cases. Good luck, sir. Marcus Alexander Calloway.
He's here, present, Judge Maine.
Mr. Calloway, you're before the court today for possession of burglary tools with intent to use, burglary of unoccupied conveyance, unarmed, and 3, resisting officer without violence. Hold on just a moment. I find probable cause for counts 1 and 2 and no probable cause for 3. As to, does the parties wish to be heard as to bond?
This is on Marcus Calloway?
Yes.
Your Honor, I'm gonna be requesting a $2,500 bond on count two. Looks like a couple years ago, Mr. Calloway went through a juvenile diversion program for the same offense.
Judge, Mr. Calloway did advise me of that. He successfully completed the diversion program. Therefore, Mr. Calloway has a clean record. Judge, he is 18 years old, been here in our community since he was 3 years old. He is going to school. He goes to Academic Solution Academy, which is in Fort Lauderdale. He is a junior, and his present GPA is a 2.5. He lives in Oakland Park with his grandmother. Grandmother's the only person that could maybe post a monetary bond, and from what he advised me, his grandmother is on disability. Therefore, because of his lack of financial resources, because he has a clean record, first I'm going to be asking the court to consider an ROR. If the court's not inclined for an ROR, then I'm going to be asking the court to consider releasing him under standard pretrial release.
What days does Mr. Calloway go to school?
Monday through Friday, Judge.
At what time? What are the times he's in school?
Let the judge know the times. 12 to 5.
12 p.m. to 5 p.m.?
Yes.
Is that a specialized school? What is it that you're studying? What are you
No,
studying?
it's not. It's alternative school.
Okay. All right. I do find probable cause, and in the affidavit it does say that the victim's did not wish to press charges. So I will release Mr. Calloway to standard pretrial release.
Here's a map of the location of pretrial students.
Yes.
It says that they do.
We're there today. If they're closed by the time you report, you have to go there first thing tomorrow morning.
They
Because
do.
if you don't, you shoot for your arrest. Do you understand,
They-
sir?
If I said do not, I do. They do, but
Okay,
that's
you said-
okay.
oh, you said do.
Yes,
Okay,
yes. But standard pretrial release, sir, and you need to make sure that you report to pretrial within 24 hours of your release. A failure to do so will lead to your arrest. Good luck, sir.
Thank you.
You're welcome. Joel Newton.
Newton is approaching, Judge.
Mr. Newton, you're before the court today for one count of burglary of an unoccupied conveyance unarmed. 2 is a resisting officer without violence. 3, 4, and 5 are burglary of an unoccupied conveyance unarmed. And I do find probable cause as to all counts. What do the parties wish to say as to bond?
Judge, I'm going to be asking for Mr. Newton to be released on pretrial release. My understanding is, and Mr. Newton also has a clean record. He's 18 years old. He's been living here in South Florida since he was 2 years old. He's currently attending Cypress Bay High School. He is a senior. His GPA 7. He actually took the SATs and scored a 1050. He wants to go to college. He lives in Fort Lauderdale with his mother, and they've been residing at that location for 3 years. So, Judge, I'm going to be Mr. Newton to be released on standard pretrial release.
I'll release, I do find probable cause, and Mr. Newton will be released to pretrial release supervision. Good luck, sir.
Here's the location of pretrial. Make sure you go there. Make sure you go there. All right? Good luck, sir.
Christian Joseph Luis Boyle.
Mr. Boyle, come on up, please.
Mr. Boyle, you're before the court for petty theft, 2nd degree. Third or subsequent offense. 2 is the theft resisting recovery of property, and 3 is a misdemeanor capious matter. I do find probable cause as the parties wish to be heard as to the bond.
Judge, in reference to count 3, it's a capious for an expired DL. He wishes to see if the state has an offer regarding that count. Having said that, Judge, on counts 1 and 2, the $750 bond, my understanding is speaking with Mr. Boyle. Right now, he financially can't afford it. Now, he did give me the phone number of his girlfriend, but he also believes that she may not be in a financial position to post the monetary bond. So we're going to be asking for Mr. Boyle to be considered be released on standard pretrial release in reference to counts 1 and 2, Judge.
Your Honor, the offer on count 3 would be an adjudication time served. I would ask that the bond on count 1 be left in place. One, it appears from what I can see here, I see one address in Delray and another address in Stewart. Mr. Boyle was released from state prison April 20th of 2018. That was after he was sentenced to 2 years and 3 months state prison on a felony theft from 2015 in St. Lucie County. He additionally was sentenced to 3-year state prison out of Martin County in 2009 for burglary of an occupied dwelling, false ownership info to a pawnbroker, and trafficking in stolen property. I'm showing a total of 4 prior felony convictions, 3 prior misdemeanor convictions. and I am showing prior failures to appear.
Okay, if
Judge,
not,
and
yes.
speaking Mr. Boyle, from what he advised me, and will correct me if it's incorrect, he says he's never been given the opportunity as far as being on pretrial. He does live in Delray Beach. He's living there with his girlfriend, been there for 7 months. So Judge, he's asking for the court to consider him on pretrial release.
All right, if Mr. Boyle wants to resolve the count 3, the offer is adjudication and time served, that's all I'll sentence him to. At this time, I will deny the pretrial release. The bond on count 1 is $750. I'll leave it at that. So what does Mr. Boyle wish to do?
Judge, he wishes to resolve count 3.
All right, sir, please raise your right hand. Do you swear affirm to tell the truth?
Yes, ma'am.
You can put your hand down, sir. Do you understand the proceedings that you're in today?
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that you have a right to go to trial? By taking a plea, you're giving up that right.
Yes.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Boyle?
No contest.
I accept your no contest plea as to count 3 only, and I sentence you to adjudication and time served. I'll give you 6 months to pay your court costs, sir. Good luck. And the bonds on count 1 remains at $750. Good luck. Kevin Tarr.
Mr. Tar, come on up, please.
Mr. Tarr, you're before the court for 1 count of petty theft. And the court does find probable cause. What does Mr. Tarr wish to do?
Judge, we're going to be asking for the court to consider releasing Mr. Tar on pre-trial release. Before I proceed, I'll see if the state has an objection.
Yes.
Okay, and Judge, he's 58 years old, been here for 17 years in South Florida. Right now, he's living in Pompano Beach. He's been there for about 3 months. Judge, he was working. Unfortunately, he lost his job. He was working for Globe Lender Capital. He was a loan officer, was working them for a number of years, making actually good money, but unfortunately, he lost his job, and he's been out of work for 2 months. He's been looking for work with no success. Judge, I believe the petty theft involves a Walmart in which the, I guess, items taken were, I believe, clothing and food. Judge, I'm going to be asking for the court to consider releasing Mr. Tar on pretrial release.
Okay, as his Broward history, 2016 felony theft, he violated probation, 270 days county jail. 2015 grand theft, VOP, 180 days. 2013 felony theft, 18 months state prison. 2013 grand theft, VOP, 18 months state prison. 2010 felony theft, 13 months state prison. 09 strong arm robbery and theft, VOP, 13 months. Theft 09, battery and theft 09, theft 09, theft 06, theft 06, loitering and prowling 06.
Judge, the only thing I want to say is, in speaking with Mr. Tar, from what I'm hearing from the state, I believe the last time he got a new law offense was well over about 3 years ago, Judge. So as far as the new law offense, any sort of petty theft was about 3 years ago. Now we're faced here with another petty theft about 3 years later. So I'm asking at this time for standard pretrial release.
All right, I do find probable cause, and I'm going to deny pretrial release at this time. The bond is $750. Good luck, sir. Ralph Paul.
Judge, he has private counsel, Miss Laura Winkman.
Do you have a phone number for Miss Winkman?
No. She's getting compensated today at some point.
So she has not yet been retained.
No, not yet.
All right. So I can't call her because you haven't yet retained her. So do you want to use the services of the public defender's office for these proceedings, or do you wish to proceed without an attorney?
No, I'll use the public defender.
Judge, I'm gonna need a moment to speak to him.
Certainly.
Have a seat.
Daniel Crescenti.
Mr. Crescenti is approaching, Judge.
Mr. Crescenti, you're before the court for one count of petty theft, and count two is a violation of felony probation. I do find probable cause. Your bond on count one is $100. On count two is a no bond hold for a felony judge. You should be before your felony judge tomorrow at 8:30. Good luck, sir. Louison Aguzme.
He's here present, Judge Amain.
Sir, you're before the court today for one count of possession or of weapon or ammo by a convicted felon. Two is a possession of cannabis 20 grams or less. Three is resisting officer without violence. And four is tampering with or fabricating physical evidence. The court does find probable causes. The parties wish to be heard as to bond.
Requesting a $7,500 bond on count one. So the court is aware Mr. Aguzme is currently out on bond for burglary of an unoccupied dwelling, impairing or impeding power or telephone lines, and resisting without violence. He is out on a total bond of $8,000.
Okay.
Judge, I'm going to be asking for a $2,500 bond on count one, leaving the other standard bonds in place. He is working. He works for a company called Sobe Vacation Home Rentals, where he's been working 2.5 years, making about $12 an hour. Judge, he's living in Fort Lauderdale with his girlfriend. The good news that he told me is his girlfriend is pregnant. He's going to be a father, and he wants to be out there to continue work to support his family. They've been residing at the same location for about 3 years now. Their monthly rental is about $1,700 per month. So, Judge, if the court were inclined to set about a $2,500 bond on count one, that's something that he believes that his girlfriend can come up with, and that's why we're requesting that monetary amount.
All right. The court does find probable cause, and I am not inclined to set a $2,500 bond. Mr. Aguzme is out on bond on other cases, and I have to take everything into consideration, and the probable cause affidavit that is presented before me. So at this time, on count one, I am going to impose a bond of $7,500. Counts two and three is $100, and count four, it's $1,000. Good luck, sir. 7500. Benson Blaze.
Mr. Blaze is approaching, Judge. He's here at me.
Good morning, ma'am.
Good morning, Mr. Blaze. Sir, you're before the court for, trafficking in heroin, 4 grams or less than 14 grams. Trafficking in oxycodone, trafficking hydromorphone, possession with intent to sell or manufacture amphetamine, possession with intent to sell, manufacture, or deliver alprazolam within 1,000 feet of a place of worship or business. 6 is a possession with intent to sell or manufacture or deliver cocaine. 7 is possession of buprenorphine. 8 is possession with intent to sell or manufacture or deliver MDMA. And 9 is resisting officer with violence. And the court does find probable cause as to all those counts.
Your Honor, just one thing, reviewing the probable cause affidavit, the offenses charged, I believe on count 5, the
Sorry.
officer's intent was just possession with intent for Alprazolam.
For which one?
Count 5. I don't believe the officer's intent was to have the within 1,000 feet enhancement.
Okay,
That's why I'm guessing there's no mention of allegations supporting that.
okay.
So I'm fine with just the possession with intent, which would make it a third degree. And I'm fine at this point with the standard bond of 1,000 to go along with count 4.
Possession with intent. All right,
These are kind of a bigger concern, That being said, Your Honor, when the court's ready, his criminal history: 2012 burglary of a dwelling, grand theft, false ownership info on a pawn item, resisting without violence, 2012. Other than that, when setting a bond the court deems appropriate, I just ask that the court take into consideration that he faces 3-year minimum mandatory prison sentences on counts 1 through 3. Nothing further, Judge.
Judge, as you could see, the total bonds on counts 1, 2, and 3 is what I want to focus on. I believe, if my math is correct, it's somewhere in the neighborhood of $225,000. That's something that Mr. not going to be able to afford, nor his family. What he does is he works for a person that repairs air conditioning systems, and he's been doing that for about 5 years. He gets about $100 a day doing that type of work. He's 24 years old, been here his whole entire life. He lives in Pompano Beach with his father and 2 children, and they're twins. They're both 4 years old. Right now, his twins are going to be going to public school next year, pre-K. So therefore, Mr. Blaze doesn't have financial resources to be able to afford the $225,000. Now, his father, he's going to be reaching out to help post his monetary bond. He's on disability. Their monthly rent is about $1,500. His father does not own their home; they rent. Now, Mr. Blaze does have property. He owns I believe, 2015 BMW, which he financed, and he makes monthly payments as far as $450 per month. And when he bought the car already had 54,000 miles on it. So right now, the bank is still the owner of it, so he doesn't have much equity in that vehicle. Judge, that's why I'm going to be requesting on counts 1, 2, and 3 a bond of $7,500 on each count, Judge.
All right, the court does find probable cause as to all the counts, and as to count 5, it'll be a possession with intent, as previously discussed. On counts 1, 2, and 3, the bonds will be $10,000 each count. Count 4, $1,000. Count 5, $1,000. Count 6, $2,500. Count 7, $1,000. Count 8, $2,500, and then count 9, it'll be $1,000. 10. All right, good luck, sir.
Thank you, Your Honor.
Talia Ramirez.
I've been informed medical reset, Judge. And Judge, I finally finished speaking with Mr. Forrester, so whenever the court's ready to proceed on Mr. Forrester.
Okay, I can take Mr. Forrester. Alfonso Forrester.
He's here present, Judge.
Mr. Forrester, you're before the court today for aggravated assault with a deadly weapon without intent to kill. 2 is neglect of child without great bodily harm. 3 is fleeing and attempting to elude law enforcement. 4 is disobey stop or yield sign. Those are not for magistrate. 5 is not for magistrate, or 6 is not for magistrate. Those are traffic infractions. I do find probable cause. What do the parties wish to tell me?
Your Honor, I'm going to be requesting a $25,000 bond on count 1, a $5,000 bond on count 2, pretrial release with a GPS monitor. Now, while he wasn't charged with aggravated assault against a law enforcement officer, I do believe the allegations would support such a charge, and I think that's something the court can take into consideration. I do have a concern that he allegedly pulled a firearm on an officer who, while it was an unmarked vehicle, was utilizing his red and, one moment, Your Honor. Pointing at an officer whose front windows were down and was wearing his department-issued tactical vest with police embroidery on it. I would note, according to the juvenile victims in the vehicle, they corroborated that Mr. Forrester was in possession of a firearm. I would also note that Mr. Forrester has 2 pending felonies right now, one for trafficking in oxycodone, fleeing and eluding law enforcement, and possession of cannabis with intent to sell. The other is for DWLS habitual offender and leaving the scene of a crash. His priors include fleeing or eluding law enforcement, DWLS habitual offender, trafficking in oxycodone 2011, tampering the evidence, 3-year state prison, false report in 2010, burglary of a conveyance, fleeing and eluding and theft 06, 3-year state prison, aggravated battery against a pregnant victim in 06, burglary of a structure and grand theft auto 04. So as you can see, there's been multiple instances prior to this where he's been convicted of fleeing law enforcement.
Judge, and speaking of Mr. Forrester, the only thing I wish to say there are 2 sides to this story, but we do understand as far as what the state said, as far as their concerns and what's going on. So under the circumstances, Judge, at this time, what the state is asking for is reasonable. So 25 on 1, 5 on 2, 1,000 on 3 with supervision, Judge.
All right, I do find probable cause, and, as to count 1, I am going to impose a bond of $50,000. $50,000. Count 2 will be $1,000. Count 3 will be $1,000. That also, with the GPS. Good luck, sir. Irving Woodrow Wilson.
He's approaching, Judge.
Mr. Wilson, you're before the court today for driving while license suspended. And then there are 2 misdemeanor KPS matters for failures to appear in court. These are from 2016. Well, 1 from 2016 and 1 in 2017. I do find probable cause. What do the parties wish to say?
Judge, under the circumstances, not at this time.
All right, so the bonds in place are $750, $500, and $500. I'll leave those bonds in place. Good luck, sir. Kyle J.D. Manuel Garcia.
Mr. Garcia is approaching, Judge.
Mr. Garcia, you're before the court for 1 count of grand theft and the court does find probable cause. The parties wish to be heard as to Mr. Garcia's bond.
Yes, Judge, I'm going to be asking the court to consider releasing him ROR on this case. My understanding is this is his first arrest ever in his whole entire life. He is 19 years old, a teenager, Judge. He's been here in South Florida for about 17 years now. He graduated from Coconut Creek High School, class of 2018. Right now, Judge, he's living in Pompano Beach with a friend who's helping him out while he gets on his feet. Judge, my understanding is at this time he's not working. He's going to be looking for work. So we're going to be asking if the state can confirm this is his first arrest ever in his whole entire life. And this being a non-violent offense, I'm going to be asking for the court to consider releasing him ROR.
He has no history, Judge.
Okay. All right. I do find probable cause, but I do have a little bit concern in the probable cause, in reading the probable cause affidavit. So I'm going to release Mr. Garcia to standard pretrial supervision. Good luck, sir.
There's the map, sir, right there. As soon as you get out today, you have to report, okay? Make sure you report. If they're closed by today, you got to go there first thing tomorrow morning.
Alvaro Manuel Valle Higgins.
He bonded, Judge.
Thank you. All right, Maine's Bonnet.
North Florida.
All right. Michael Catania.
Conti, Your Honor.
All right, Mr. Catania.
Yes, ma'am.
Good morning, sir. We did find probable cause before Mr. Catania is brought back for a bond. Does the parties have wish to be heard?
Your Honor, I believe the bond was originally $500. I'm going to ask that it be set back at $500. I believe this was an issue more having to do with booking than new circumstances. Additionally, Mr. Catania has come before this, and through this division multiple times recently. I know he's come through on a couple carrying concealed weapons within a recent time span of one another. He's been put on pretrial. I believe he's violated pretrial. So that's why I'm just asking the court to put him in the same position he was in at his original first appearance. It was what?
It was $750.
That's a different charge than this.
All right.
$750 was originally on the theft offense.
Can you make that bond, Mr. Catania?
For what is for all of it is $750?
No. You're just here for one count today of the burglary of an unoccupied structure and unarmed. I do find probable cause, and I'm going to set the bond at $500. Good luck, sir.
All right, thank you.
Okay. Levin Adkins. Devin.
Mr. Atkins is here at Main, Judge, approaching. And Judge, whenever the court's ready, I'm also ready to proceed on Mr. Ralph Paul.
Okay, so Devin Atkins, Mr. Atkins, you're before the court for one count of battery on an officer or firefighter, disorderly intoxication in a public place, 3, corruption by threat to a public servant or family, and 3, resisting officer with violence. This was also a medical reset. And the court does find probable cause. What do the parties wish to say?
We'll be requesting bonds in the following amounts: $1,500 on 1, $2,500 on 3, $500 on 4. And no return to this Walmart on Turtle Creek Drive in Coral Springs.
All right.
Judge, I'm going to be requesting on counts 1 and 3, $1,000 on each count. Mr. Atkins is 30 years old. He's working. He works for a company called Boca Moving Group, making about $15 an hour. He lives in Delray with his girlfriend. His girlfriend is employed. She works for an insurance company, and that's who he's going to be reaching out to post his monetary bond. He believes if the bond is set in around 1,000 on 1, 1,000 on 3, and if it's a $500 bond on 4, it still has to pay the 10%, which would be the premium. The same with the bondsman. If it's 500 or 1,000, he believes that his girlfriend can afford that, Judge. I'm also going to ask the court to sign a photo order so we can photograph the injuries that Mr. Atkins sustained as a result of his contact with law enforcement, Judge. And as you see, he's been in medical research. I believe he was in the hospital, or rather getting medical care. So I believe 1,000 on 1, 1,003 is reasonable.
All right, the court does find probable cause, and I find that the reasonable bonds to be set on this is count 1 will be $1,500, count 2 will remain at $25, count 3 will be $1,500, and count 4 will be $500. Good luck, sir. All right, and then we can call Mr. Ralph Paul.
Paul's approaching, Judge.
Mr. Paul, you're before the court today for selling heroin within 1,000 feet of a school or child care. 2, possession with intent to sell, manufacture, or deliver cocaine within 1,000 feet of a specific area. Possession with intent to sell, manufacture, or deliver MDMA. Possession with intent to manufacture, sell, or deliver alprazolam. Possession of controlled substance without prescription. Possession of drug paraphernalia. And 7 is a violation of probation violation. The court does find probable cause as to all counts. While I don't have a time for you to be going to your felony court, it is usually within, you have it?
It's out of Palm Beach.
Judge, and speaking, Mr.
That's
Paul,
right,
considering
it's a Palm Beach, no bond hold.
Considering as of no bond hold on the VOP, Judge, nothing to add from the defense.
All right, the court does find probable cause, and I'll leave the bonds in place as they are. Thank you. Tarod Verdell Barnes.
If my office entered some data incorrectly.
Well, I didn't get any of it. So,
Your Honor, I imagine on your, and I won't go into too much detail about the charge, I'll just state, I imagine on your findings, and I can see in the booking, it says, these both involve charges of victim less than 12.
yes.
Okay. Your Honor, I provided the court with the information that we filed, and you see that that's not accurate. What happened was when we did our filing instructions, we put the wrong offense in the filing instructions. So technically, count 1 should have never been a change of charge, since that's the same offense that I believe Judge Malika found probable cause for originally. And charge number 4 is just an add charge.
Okay.
In light of that, I'm going to request that the court set the bond on count 1 that was originally set, $100,000 with the same release conditions, and I provided the court with a copy of the findings. And I'm going to be requesting a $50,000 bond on charge 4. I also provided the court with a copy of the original probable cause affidavit. Since there's an add charge, I imagine, in case the court wanted to familiarize yourself with the allegations.
All right, thank you. So as to count, I do find probable cause, and as to count 4,
Judge,
yes.
in speaking, Mr. Brown, is he being held no bond on another matter?
Yes, he has no bond holds on counts 2 and 3.
Judge, at this time, the defense would be deferring any bond argument to be made in front of his assigned division judge.
All right, so on the count 4, the bond will be $50,000, and then the count 1 will be well, it was already 100,000. We'll just keep it at 100,000.
And all the other same conditions,
And
Judge?
all the other conditions that were previously entered by Judge Malika. All right, good luck, sir.
Judge, there's one more gentleman here. He is on page 19 of your docket, Mr. Larry Bostic, on a VOP, I've been informed, I guess confinement status, requested his presence here today?
Yes, I do, I was presented with this at the last minute, so Mr. Bostic is here for a violation of probation matter, and
Because it's on a 94806, Your Honor, and not an actual warrant, it's required for the court to make a PC determination one way or the other for him to be held.
all right, another detective who wants me to go blind. Can't read this handwriting.
I can,
All right. All right, I do find probable cause. Mr. Bostic will be held no bond on the violation of probation until he's able to get to his division judge. Good luck, sir. All right. Are we at the end of the docket?
yes, ma'am.
Well, thank you, everyone, and I will see you this afternoon.